Thank you. The gentleman from Iowa, Mr. King, is recognized for his questions.
Thank you, Mr. Chairman. Appreciate this hearing today, and I think that there have been a tremendous amount of instructive testimony that's come out from each of you. And I look at the bookends. Mr. Cuccinelli and Mr. Barnett have made, I think, the arguments that I would be making. And so rather than turn directly to either one of the gentlemen, I'd go to Mr. Dellinger, who probably hasn't quite had enough time to air his position. And I would first take it to this point as I listened to the discussion about Wicker v. Filburn, and we got a couple of follow-up questions for you, Mr. Dellinger. So I just ask, do you believe that Wicker v. Filburn was justly and rightly held?
I do.
And rather than go into my disagreement with that, I think that expanded the Commerce Clause beyond the intentions of the Founding Fathers or the concepts that we basically hold today. Then would you describe what you think, if Obamacare is upheld as constitutional and the provisions of the Commerce Clause are, you might argue, not expanded, I would argue they would be expanded if that were the case, then what could be constrained by the Commerce Clause? What type of activity would be constrained? Where would the boundaries be?
That's a very good question. And it would depend, of course, on the kind of opinion the Supreme Court wrote upholding the law. In my view, the Supreme Court in upholding it will say, first of all, nothing we uphold today gives Congress any power to regulate local non-economic matters unless they have some special showing of relation to interstate commerce. So nothing we hold today undercuts United States versus Morris, United States versus Lopez, regulating local non-economic matters is something Congress cannot generally do. Secondly, they would say, we think when Congress imposes affirmative obligations, it has to show that that's really tightly related to, that I expect them to say, Congress has to show that there is a substantial relationship to a regulation of commerce. And the substantial relationship here would be that this is part and parcel of a regulation of insurance contracts that prohibits denial of coverage for pre-existing conditions to provide a financial incentive for people to participate. It does not provide, our opinion today, they will say, does not mean that Congress could simply require anyone to purchase anything in order to stimulate the economy.
Okay, and then quickly, before I go to Mr. Barnett, could you tell me the distinction? I just heard the language use health care and health insurance, and the distinction between the two was blurred in your opening testimony. Could you just draw a distinction between the two?
I think both of those markets are markets, obviously, which Congress can regulate under its commerce power. They account for 1/6 of the national economy. Health care is unique in that no one can decide not to utilize it. Health insurance is how you pay.
Would you agree that it's been a practice to conflate the two terms, and it makes it difficult for us sometimes to sort the two when we use the term health care interchangeable with health insurance, and we should do a better job of being careful how we use that terminology? Yes. Let me just make that a statement because the clock's ticking. I thank you for your testimony.
Yes.
And I turn to Mr. Barnett. Would you care to respond to the response that you've heard from Mr. Dellinger, Professor Dellinger?
Yeah. It's what I said in my opening statement, Mr. King, and that is that we've heard no principle of no constitutional principle. The Supreme Court will write, if they uphold this bill, they'll write an opinion. They'll talk a lot about health care is different, but then they'll say we must defer to Congress's assessment that this was necessary in order to impose insurance requirements. So they'll defer to you. Is basically what the opinion will be how it will be written. They will not identify a limiting principle if they uphold this bill. At least we have not heard from any of the proponents of the bill a constitutional principle that the Supreme Court could enunciate. If they say health care is different, what I'm saying that to you is that never in the history of this country has the Supreme Court gotten into a factual determination saying, okay, well, health care is different, that's okay, but this other market for cars, let's say, that's different, there's a constitutional difference between the two. They haven't ever said that, and they're not going to say that.
They're likely then if the Supreme Court upholds, then they'd leave the discretion to Congress to define, because they'd be reluctant to. Mr. Cuccinelli, you add to that?
I would just say that I'll bet you that Professor Dellinger would take that bet, that he would not want to take the bet that if the Supreme Court upholds the mandate, that they won't say that in the future it's up to Congress to decide whether to impose mandates.
General Cuccinelli?
Well, actually, Mr. Dellinger and I were on a panel in October at the Washington Legal Foundation, and when he was asked the principle at that time, he said the limits would be political. And I agree with him. I think that is the absolutely dead-on, accurate, honest answer, and that means majority rules. And if that's the case, why have a Constitution in the first place?
I'll accept that as a closing remark and yield my time back to the Chairman. Thank you very much.
Thank you, Mr.